There are moments in history that happen with a bang, a gunshot, a speech, an explosion. But the most dangerous moments usually happen in silence. We have just witnessed a judicial earthquake so powerful it has effectively liquefied the legal ground beneath a former president of the United States. Donald Trump and his entire legal team have been plunged into a state of absolute frozen shock. We are watching a historical pivot point that almost no one predicted. The consequences for the Trump camp are nothing short of terrifying. Before we untangle the specifics of this legal ambush and explain why reports suggest Trump is spiraling into a panic, I need you to understand one thing. This was invisible. For over a year, a secret war has been raging in the federal courts. A war fought with sealed documents, redacted motions, and ghost docket filings that the public never saw until now. In a decision that legal historians and constitutional scholars are already labeling as unparalleled in the history of American law, the Supreme Court has decreed that Donald Trump must immediately, without any hesitation, delay, or appeal, surrender records that his own lawyers may not have fully realized were still in play. This isn't about the hush money. It isn't about the classified documents in the bathroom. It isn't even about January 6th. This is a fourth front, a shadow front, and the Supreme Court just turned on the lights. If you are looking for the raw, unvarnished truth about these courtroom battles, details the mainstream news often skims over, you have found your home. Join our growing community right now. Click subscribe. Toggle your notifications because the countdown has begun. We are at T-minus 72 hours. Let's dissect the anatomy of this cataclysmic ruling. On December 7th, the Supreme Court released an opinion that did not appear on the public calendar. There were no oral arguments televised on C-SPAN. There were no press releases issued to the media beforehand. 1 minute, Donald Trump thought he had a map of the legal minefield he was walking through. He thought he identified every threat. The next minute, the earth opened up and he fell into a legal abyss he didn't even know was there. The ruling pertains to a sealed grand jury investigation that has been operating in the dark, running parallel to every known prosecution for over 14 months. The court's order is blunt. It commands the immediate surrender of 1. Financial records, stretching back to 2015. 2. Internal business communications, involving foreign entities. 3. Documents related to national security matters that remain redacted. It is genuinely hard to wrap one's mind around the fact that the Supreme Court successfully kept a proceeding of this colossal importance entirely under wraps. We are discussing a clandestine legal war. Even Trump's lead defense attorneys were reportedly oblivious to the finality of this decision until the gavel came down. There was absolutely no window for Trump's public relations machine to spin the story. This ruling exposes that a covert investigation has been active this whole time, one involving evidence so sensitive, so potentially destructive, or so vital to national security that the mere existence of the subpoena had to be classified as a state secret. Why is this shocking? Because the Supreme Court is usually the gold standard of transparency. In the normal course of business, cases are placed on the public docket. Briefs are filed in the open, but the court holds a rarely used power, a nuclear option of judicial procedure, to hold proceedings entirely under seal. This power is reserved for moments when the nation's security hangs in the balance. The fact that they invoke this power here communicates everything you need to know about the severity of this matter. According to the text of the ruling, this sealed saga began more than a year ago. It originated when a grand jury in Washington, D.C. fired off a subpoena. Because this subpoena was issued under seal, when Trump was served, he was simultaneously gagged. He was legally forbidden from whispering a word about its existence to the public, to his political base, or to the press. Now here is the twist that makes this narrative so unbelievable. Trump apparently fought the subpoena through sealed filings. He waged a war in the dark, recycling the exact same arguments about absolute immunity and executive privilege that he has shouted in his public trials. He tried to use the same old playbook. But in the dark, without the glare of the media to pressure the judges, those arguments collapsed. The lower court struck them down. The appeals court struck them down, and now the Supreme Court has struck them down in a final, devastating ruling. The opinion, written by Chief Justice John Roberts, is direct and merciless. It declares that the subpoena is hunting for documents related to conduct that lies completely outside any reasonable claim of presidential immunity. It continues by asserting that the defendant's efforts to stall and obstruct compliance have been fully exhausted, and that no further procrastination will be tolerated. Legal analysts note that the language implies this conduct is entirely distinct from the classified documents case in Florida. This appears to be a separate beast entirely. Consider the other rulings. When the court shot down his claims of immunity earlier this year, Trump's team saw it coming. They had argued the case in open court. That ruling was a hit, sure, but it was a telegraphed punch. This ruling is structurally different. It is a sniper shot. So how did the Trump team react? According to reporting from the New York Times and sources close to the defense, the atmosphere at Mar-a-Lago was absolute pandemonium. Trump's attorneys found out about the ruling from breaking news alerts, not from the court itself. The sealed nature of the process meant that even standard notifications were embargoed. One insider depicted the scene as chaos, with lawyers scrambling to figure out which documents were even captured by the subpoena. Remember, this case has been handled by a small circle of attorneys with security clearances. The broader legal team didn't know the details. Then, we must look at the pattern of how Trump usually reacts. When he encounters a setback, he attacks. He goes on Truth Social. He holds a rally. But this ruling leaves almost zero oxygen for that strategy. The subpoena has already been litigated. The Supreme Court's decision is final. There are no more appeals to file. The deadline for compliance is exactly 72 hours. From the moment the decision was released, we are not talking about weeks, we are talking about 3 days. And the court added a detail that legal experts are calling extraordinary. The opinion explicitly states that any failure to comply fully and in good faith will trigger immediate civil and criminal contempt proceedings, with sanctions that include potential pretrial detention. The Supreme Court is essentially holding a loaded legal weapon to his temple. They are warning Trump that if he attempts to stall, obstruct, or provide half-baked responses, he could be thrown in jail pending trial. This reflects a court that has completely run out of patience. They have watched him attack judges, defy orders, and treat the American legal system like a political prop. This ruling signals that they are finished tolerating it. What exactly is in this subpoena? Why is Trump's legal team in a meltdown? It comes down to 3 categories of evidence that appear far wider and more destructive than anyone dared to guess. Category 1, the money trail. Prosecutors are demanding complete financial records from Trump's business empire stretching back to 2015. This dragnet includes every transaction involving foreign entities, all loans, and their specific terms. This strikes directly at questions of financial fraud and potential money laundering that have hovered around Trump for years, but have never been definitively proven in court. Category 2, the foreign connection. They are demanding all communications between Trump and certain foreign nationals, whose names remain redacted. The court's opinion cites national security concerns as the reason for keeping these names under lock and key. This isn't just about business partners. This implies involvement with foreign governments or intelligence assets. Legal analysts are theorizing this could involve back-channel discussions with foreign officials that occurred after his presidency. Category 3, the election interference. Perhaps most explosive, the subpoena seeks documents related to what the ruling describes as efforts to obtain things of value from foreign sources in connection with electoral activities. This language mirrors federal statutes almost verbatim. It suggests an investigation into whether Trump or his campaign solicited illegal foreign assistance, a charge that strikes at the very heart of democratic integrity. These document categories overlap with but extend far beyond his existing cases. The financial records could unearth entirely new instances of fraud. The foreign communications could trigger Espionage Act violations. Trump's attorneys are trapped in an impossible position. They have 72 hours to compile documents spanning a decade. They are tasked with reviewing potentially millions of pages for privilege claims, all while knowing the court has signaled it will tolerate zero delays. One attorney reportedly described the task as being asked to empty the ocean with a teaspoon. But the logistical nightmare is only a fraction of the problem. The substantive threat is far worse. Whatever Trump has been concealing in these documents is about to be exposed to the light, and there is a new variable in the equation. According to sources familiar with the matter cited by Politico, a cooperating witness, someone previously inside Trump's inner circle, is providing context about the sealed subpoena. This witness reportedly possesses knowledge of specific documents Trump tried to hide. They can testify about conversations where Trump discussed what would happen if these particular records ever saw the light of day. If this is true, it means prosecutors don't just have subpoena power, they have a more roadmap and they know exactly what to look for. They can compare what Trump turns over against what the cooperating witness says should exist. Any missing documents, any suspicious gaps will be immediately apparent. This is the classic perjury trap. If Trump withholds a document that the witness has already told prosecutors about, he commits a new crime, obstruction of justice. This leaves Trump in a corner where every single exit leads to disaster. Option A, comply. If he complies with the subpoena and surrenders the documents, he is handing prosecutors evidence that could reveal entirely new criminal liability. Whatever he has been hiding becomes part of the official record. Option B, defy. If he defies the order, he faces immediate contempt proceedings. The court has already warned that sanctions could include jail time. Trump could find himself sitting in a cell, not for the crimes he has been charged with, but simply for refusing to obey a lawful subpoena. And let's look at his reaction. Within hours of the ruling, Trump took to Truth Social. He attacked the justices. He claimed the proceeding was unconstitutional. He explicitly stated he would not comply with an illegitimate order. Legal experts immediately sounded the alarm. Former federal prosecutor Andrew Weissman noted that when a defendant announces publicly that they intend to defy a Supreme Court order, prosecutors don't have to struggle to prove intent. The defendant has already confessed to it. Trump's public statements are practically a written invitation for contempt proceedings. The panic is spreading beyond Trump's inner circle. It is infecting his defenders in the media. Conservative legal commentator Jonathan Turley, who has often defended Trump, appeared on Fox News and acknowledged that the ruling presents an existential threat to Trump's legal position. Turley noted that the existence of sealed proceedings suggests prosecutors have evidence of conduct serious enough to justify extraordinary confidentiality measures. That is not a good sign for Trump when even sympathetic legal analysts can't find a way to minimize the damage. On the other side, Lawrence Tribe, the renowned Harvard constitutional scholar, called this ruling the most consequential Supreme Court decision regarding a former president since United States versus Nixon. Tribe noted that while the sealed procedure is extraordinary, it is apparently justified by national security concerns that we may not fully comprehend for years. This brings us to the most terrifying question of all. What do the intelligence agencies know? The existence of this proceeding suggests information so sensitive that even confirming the investigation would cause harm. Does it involve nuclear secrets? Does it involve the identities of American spies? Does it involve a transactional relationship with a hostile foreign power? We may never know the full details, but the Supreme Court has seen the evidence, and their reaction was to order immediate compliance under threat of imprisonment. This ruling creates extraordinary uncertainty for the 2024 election. Trump is running on a platform of fighting the corrupt system, but this ruling reveals that the system has been investigating him in ways he didn't even know about. How will his supporters process this? Some will view it as further evidence of the deep state, but others may start to wonder, what has he been hiding? According to recent polling from YouGov, a significant majority of Americans, including a growing number of Republicans, believe Trump should be required to comply with lawful subpoenas, even if the materials might be incriminating. The principle that no one is above the law still resonates. Democrats will certainly use this ruling to reinforce their message about Trump's unfitness for office. They will argue that a candidate who has been secretly fighting to hide evidence from prosecutors cannot be trusted with the nuclear codes. So, here is the reality. The Supreme Court just revealed that a sealed grand jury proceeding has been investigating Donald Trump for over a year. They ruled that he must comply with a subpoena for financial records, foreign communications, and documents related to electoral interference. Compliance is required within 72 hours. Refusal will result in contempt proceedings and potential imprisonment. Trump was blindsided. His legal team is in chaos. And the scope of the subpoena suggests prosecutors are investigating conduct far more serious than anything we have seen before. This is the legal equivalent of an ambush. Trump spent a year fighting in secret and lost. Now he has no options left: comply and hand over the evidence, or defy and go to jail. The clock is ticking. Prosecutors are waiting. The nation is watching. Donald Trump is facing the most dangerous moment of his legal life. Whatever is in those documents, whatever secrets he has been desperately trying to keep in the dark, we are about to find out. This is the moment of truth, and it is arriving faster than anyone expected. If you made it this far, you understand the gravity of this situation. Don't forget to like this video, subscribe to the channel, hit that notification bell. We will be back the moment that 72-hour deadline expires to tell you what happened. Thanks for watching, and stay vigilant.